Hello everyone, I am Ishrat. Thank you for giving me the opportunity to come here and speak. Today I'd like to talk about whether the current legal framework for land ownership and registration is fit for its purpose. I would also like to talk about the fundamental principles of current land law and if it's upheld in practice. And I would talk about the current Land Registration Act and if it's perfect or does it need any reforms. In England and Wales, land and matters relating land was governed by the Land Registration Act 1925, which was backed by Land Registration Rules 1925. It has, however, become more evident towards the end of 20th century that the old framework was not enough to support the needs in a growing property market. The Land Commission and Land Registry then joined in a large-scale reform project and produced a joint report in 2001, which formed the basis of Land Registration Act 2002, which repealed the 1925 Act and currently governs the majority of land in England and Wales. This act modernized the registration system. At the center of this modern registration system is the so-called mirror principle, which aims to ensure that the land registration provides a complete and accurate reflection of all the rights and interests affecting a piece of land. It, together with curtain principle and insurance principle, serves as a foundation of integrity and reliability of all the registered land. However, at the same time, even with such ambitious changes, people still face multiple unresolved issues. They include the fact that unregistered land still exists, and there are issues regarding the complexity of law and its overriding interest. There is a problem of delaying regarding the implementation of technologies. I would discuss how the principle of mirror works, its use, its shortcomings, and I would suggest some recommendation to make land registration system work in the 21st century. One of the cornerstones of registered land system provided under the Land Registration Act 2002 is the mirror principle. It stipulates that land registration is supposed to be a complete, accurate mirror image of all the rights and interests affecting the land at any given time. Theoretically, any person working with land should only have to refer to the register to get the entire legal picture of the situation, such as who owns the land, what rights or restrictions may be there over the land. This principle assists in making transactions more simpler and easier in the sense that it eliminates the necessity to conduct a lengthy investigation to ascertain whether or not title to the land is held on trust by pointing out past ownership of registered interest in the land. It is most effective where rights are well captured and the register reflects a reasonable picture indicating a definite and trustworthy snapshot of a property status. The mirror principle operates alongside two fundamental principles of the registered land, such as the curtain principle and the insurance principle. The rationale behind the curtain principle is to streamline the conveyancing process by screen out some of the equitable interests, especially those which emerge under a trust, so that they do not need to show up on the register. The point of such consideration is that purchaser will not be interested in tricky background details. They only get involved with legal estate that is visible on the register. To give an example, when land is held on a trust, the register shall only record the name of the legal owner and not the beneficiaries. The doctrine lightens the responsibility on the buyer as they do not need to do a research on trust schemes lurking behind the curtain. The principle of insurance complements when principle of mirror fails. It arises out of the fact that such register would be insured of accurate details and users of the register would not lose financially since they relied on inaccurate accounts or missing accounts. In case one is affected by a loss due to an erroneous register, the land registry is able to redress the mistake. In the event that it cannot be rectified through rectification being unjustly biased against a third party, the aggravated party can gain money rewarding by an indemnity scheme managed by the state. This principle guarantees that the system and trust to be followed and makes protection available to anyone who is in good faith is utilizing the register. So, in theory, although mirror principle along with two others aim to make property transactions more secure and swift, they are not fully upheld in practice. Perhaps the most striking breach of the mirror principle arises from overriding interest. To define what overriding interest means, these are considered special rights that they are applied on the land despite having no mention in the land register. This implies that an individual may be legally entitled over a certain property and yet this right will hold notwithstanding the fact that this is not in the land register. It is commonly called out as a crack in the mirror as it interrupts the thought that the register reveals all rights and interests of all rights that interest the land. These interests are governed by Schedule 1 and Schedule 3 of the LRA 2002 and are not subject to the doctrine of notice. Among all the overriding interests, the rights of a person in actual occupation are the most significant and frequently litigated. These rights can override a registered disposition such as a sale or mortgage of land, even if they are not recorded on the register. For such rights to override, three key requirements must be met. 1. Proprietary interest. 2. Actual occupation. And 3. Knowledge or obviousness. In order to assert the claim to override interest under Schedule 3, Paragraph 2 of the Land Registration Act 2002, an individual must have proprietary interest in the land. Rights of mere personal character are not adequate, and the occupation of person can also override interest, which I just mentioned. Let's look at some of the case laws regarding actual occupation and proprietary interest. In the case of William and Glenn's Bank and Boland, Mr. Boland's wife had a beneficial interest in the house due to her financial contribution. When Mr. Boland mortgaged the property without her knowledge and defaulted, she claimed that her interest should take priority over the bank's. The House of Lords ruled that her equitable interest, coupled with her actual knowledge, constituted an overriding interest that bound the bank. It confirmed that a spouse's unregistered beneficial interest under a trust can override registered dispositions. Another case is Webb and Polmount Limited, where a lease contained a contractual option to purchase. The tenant remained in actual occupation when the property was sold. The new owner claimed that the option did not bind them because it was unregistered. The court held that the option to purchase was a proprietary right, and since the tenant was in actual occupation, the option was protected as an overriding interest. But on the contrary, in the case of Hypo Mortgage Services Limited and Robinson, a mother and her minor children occupied a home. She had a beneficial interest, but the children had no independent legal right. When the property was mortgaged, the children's continued occupation was raised as a defense. The court held that the children's occupation was dependent on the mother's and did not create a separate proprietary right. In the case of Chokar and Chokar, the wife's temporary absence due to hospitalization did not defeat her actual occupation. She retained an overriding interest despite the secret sale of the home. In the case of Link Lending Limited and Bustard, despite being detained in a psychiatric hospital, the claimant was in actual occupation due to her regular visit, possessions in the property, and clear intention to return, which gave her an overriding interest. But on the contrary, in the case of Stockholm Finances Limited and Garden Holdings, a Saudi princess's infrequent visit and long absence from the property meant she was not in actual occupation, so no overriding interest arose. And in the case of Thompson and Foy, the mother's permanent departure and signed transfer of interest showed she had no intention to return, so she was no longer in actual occupation and had no overriding interest. So from these cases, it can be said that to determine if there was an overriding interest, the courts will assess physical presence, intention to return, and the nature of occupation. But mere presence without a proprietary interest is not sufficient. This was also confirmed in the case of Abbey National Building Society and Ken, where the court held that to override, both proprietary right and occupation must exist at the same time of disposition. So, for knowledge and obviousness, a purchaser may be bound by unregistered interest if the occupier's presence is known or obvious to them, but protection is lost if the occupier fails to disclose it when it is expected. This creates uncertainty and undermines the mere principle by allowing hidden interest to affect the registered land. In principle, the mere principle represents the idea of simplicity, transparency, and certainty in land ownership. However, in practice, it is only partially upheld due to continued existence of overriding interests, especially those based on actual occupation, as well as the persistence of unregistered land and administrative shortcomings. These issues expose buyers to hidden risk and undermine the reliability of the register. Thus, while mere principle remains a valuable idea, it is clear that further reform is needed to make the fundamental principles, especially mere principle, work even better. Other than these, there are some additional challenges to the mere principle, such as Despite the LRA 2002's push-up for universal registration, around 10% of the land in England and Wales remained unregistered. This means transactions involving such land still requires old deeds, contradicting the goal of a fully transparent system. Second challenge, I would say, is the human error and administrative failures. So, in the case of Baxter and Mannion, the register was wrongly updated due to an erroneous adverse possession claim, undermining the principle that the register reflects legal reality. Another challenge is basically technological limitation. While the LRA 2002 has modernized property law, it is not fully delivered on the promise of a comprehensive, accurate, and self-contained register. The persistence of hidden rights, unregistered land, and manual process keep the registration from fully reflecting ownership reality, which demonstrate the Act is still in need of reform and make land-related matters truly hassle-free and transparent. So considering all the lackings and gap I just talked about, the law governing the land, I think needs some reform. So I'm here recommending some of the reforms I think that needs to be made to make the law even work more efficiently in 21st century. The first one is narrow the scope of overriding interest. This weakens the certainty of the register, requiring formal registration of beneficial interest and clear disclosure duties during transaction would help limit these hidden rights. This reform would strengthen the mere principle and improve transparency in land ownership. Second one, I think, is mandatory disclosure by occupiers. Occupiers with potential overriding interest are not always required to disclose them, creating risk for purchasers. Introducing a legal duty to declare such interest during land transactions would reduce hidden claims and enhance the reliability of the register. The third one is complete the registration of all lands. A significant portion of land in England and Wales remains unregistered, undermining transparency. Enforcing compulsory registration would ensure a complete modernized land register and reduce dependence on outdated land deeds. The fourth one is accelerate the transaction to full conveyancing. The shift to electronic conveyancing under LRA 2002 has been slow. Investing in secure digital system and mandating their use would streamline transactions, reduce error, and improve accessibility and efficiency in land dealings. And the fifth one is clarify the relationship between overriding and overreaching. There is an ongoing confusion when overreaching removes overriding interest, especially in cases involving actual occupation. A clear legislative guidance would promote legal certainty, protect equitable interest, and reduce disputes. So to conclude everything, the mere principle central to the Land Registration Act 2002 is intended to ensure that land register offers a complete and accurate reflection of all the property rights and interests. In theory, this principle simplifies conveyancing and provides certainty by allowing anyone to rely on the register without needing to investigate further. However, in practice, the mirror is not flawless. The continued existence of overriding interests, especially those based on actual occupation, undermines the reliability of the register. Cases such as Williams and Glyn's Bank and Boland and Link Lending and Buster demonstrates how rights can bind purchasers even when unregistered, exposing a significant gap between principle and reality. Moreover, issues like unregistered land, human error, and delays in technological progress further compromise the system's integrity. While the Land Registration Act 2000 modernized property law significantly, these unresolved weaknesses show that the Act is still evolving and far from perfect. To uphold the promise of the mere principle, targeted reforms are essential, which I just mentioned, such as narrowing the scope of overriding interest, mandating disclosure by occupiers, completing universal land registration, and so on. Only through these changes, I feel like the land registration system can truly achieve its goal of being transparent, secure, and fit for the demand of 21st century.